Smith v Leech Brain Co Ltd, 1962, is a vital English tort law case that established the modern application of the Eggshell Skull Rule in negligence. The rule simply states that a tortfeasor must take their victim as they find them. Unforeseeable pre-existing physical or psychological susceptibilities do not acquit a defendant of liability for the ultimate damage caused. Hello and welcome to Landmark Case Laws Simplified. Buckle up as we explore the fascinating world of Smith vs. Leech Brain together. Mr. Smith worked for Leech Brain Co. One day on the job, molten metal splashed onto his lip because his employer didn't take proper care. The burn was actually pretty minor. But what nobody knew, neither Mr. Smith nor his employer, was that he already had a pre-cancerous condition. The burn triggered cancer, and sadly, Mr. Smith died. His widow brought a claim against the company, asking for damages. The legal issue here is, was the company on the hook for everything that happened, including the cancer and Mr. Smith's death, even though nobody could have seen that coming? The court said yes, the employer was fully responsible for Mr. Smith's death. This case really hammered home the Eggshell Skull Rule in tort law. You have to take your victim as you find them. So, if you injure someone through negligence, you're on the line for every consequence, even if the person you hurt had a hidden weakness, and the damage ends up being way worse than anyone expected. It just matters that some kind of physical injury was foreseeable. Once that's true, you're responsible for everything that follows, no matter how extreme. Smith v Leech Brain made it clear, defendants can't dodge liability just because the person they hurt was unusually fragile. It doesn't matter if the results are way more serious than you thought, they're still linked to your negligence. This rule protects people who have hidden conditions and makes sure they get justice. Let's say you lightly shove someone with brittle bones, and they break a bunch of them. You're still fully responsible for those injuries, even if you had no idea about their condition. Want to see how this stacks up against cases like Wagon Mound or Robinson v Post Office? Subscribe for more legal insights. Thanks for watching.